Hi, so this is IP protection for product designs. We're excited to talk to you today. My name is Ann Weeks. I am a third-year law student at Boston University School of Law.
And I'm Ian Mahaney-Horton, also a third-year law student at BU, and we're both registered patent agents at the Patent and Trademark Office.
Yes, that's what those numbers are. Yeah, and so we are members of the Boston University Startup Law Clinic. We practice under the supervision of 3 licensed attorneys, and we handle a whole bunch of matters for startups started by students at MIT and BU. And again, today we're talking about IP protection for product designs, which is exciting. Okay. Apologies, I think I muted myself by accident. All right, so an overview of the talk today is we're going to go through why you would want to protect a product design, what options do you have, so what forms of IP are used to protect product designs, and how do you think through which ones are best for you. This will be good. All right, so classic disclaimer, intellectual property law, like a lot of law, is extremely fact specific. So we strongly recommend that you consult an attorney to handle your particular situation. Nothing in this presentation is meant as legal advice. What we're doing here is giving you enough information so that you can think about this in an educated manner and go out and seek advice on your particular situation. Some of these forms of IP are things that we do at the Startup Law Clinic. So if you're a student at BU or MIT, we would be happy to talk to you about this. All right. So product designs can be powerful branding tools. This is probably kind of straightforward for everyone, but we like to say it out loud. So how many times have you bought a product, at least in part because of how it looked? When there's a marketplace with a lot of different options out there for the same functionality, design can be very powerful in attracting people to one brand or one product over another. So for example, you see these shoes, the color, the shape, that swoosh on the side. These are Nike Air Jordans. That becomes something that people see and decide that they would like to buy, as opposed to other shoes. There are a lot of other shoes out there that do similar things. An iPhone, the nice rounded edges, the matte, the reflective screen, the placement of the camera, and this lovely coffee pot is an iconic design. And so this can help they can help your company to make a mark on the marketplace with your particular product design. So one thing to be clear about in this presentation is we're talking about protecting a product design as opposed to protecting the product itself. So IP protection of how a product looks is separate from protection of how it works. And if you think about this, this is good for a couple of reasons. So if you redesign something that's already existed, you come up with a beautiful Chemex coffee pot or something. You didn't invent the coffee pot, but you redesigned it so it's really beautiful and people like it. You can protect that design contribution. Another example of this that I like, I use these, is an Apple computer. So the color, the minimal shape, people can really like that. And if that's something you come up with, maybe you didn't come up with a computer, but you came up with a beautiful design, that can be really powerful in establishing yourself in a marketplace. And another good thing is that if you've invented something new and you've created a particular design for it that is really lovely and people like, you could protect both the thing you invented and the design that you came up with independent of each other. And that gives you the opportunity to provide more protection for your product through those 2 forms or multiple forms of IP, so that it's even harder for competitors to copy what you've done. That gives you an edge. So one of the wrinkles here is that for these protections of a product's design to apply, the design can't be closely linked to function. So the forms of IP that protect design are not meant to protect how things work, just how they look. And so you have to really think about, is the design separate from how the product works? Would the product work if it looked different? So here we have a Ferrari. Ferraris have a very iconic, famous design. And so you would have to think, does the design of the car, the color, the shape of the various pieces affect how it looks? Does the shape of a wheel affect how it looks? Yeah. Is there a rim design that you could protect with for a design? Probably, because that may or may not be functional. But it's not just protecting the engine versus protecting the outside. You have to think about reducing drag, air resistance. So it can be quite complicated to think about the difference here. But just important for our talk for you to understand that what we're talking about is how things look, and that needs to be separate from how they work. So what IP protections are available for product design? So there are 3 forms of IP that can be used: a design patent, trade dress, copyright. And just to note, it is possible to pursue all 3 for the same design. So we're going to walk through these 3 forms for you and go over what they cover, what they're good for, because even though these 3 things cover product design, they're not all meant for the same thing. And it's important to know what each one of their strengths and what the drawbacks are. And again, it's possible to double or even triple. You can use more than one of these IP forms. You can just use one. You could use all 3. So for example, a very common route is to get a design patent to cover a product while it develops brand name recognition or distinctiveness, which is needed for trade dress protection. If a lot of that stuff seemed a little legalese, we're going to get into those definitions, so it's understandable in just a minute. And one thing to understand, though, is just because you can get multiple forms of IP protection doesn't necessarily mean that you should. You need to think about your particular situation, because each one of these things costs money, costs time to go after, and so it can be expensive time and money-wise, and you should really think about what's important for your view for your startup and how you're going to work in the marketplace. And I'm going to hand it over to Ian for design patents.
All right, thank you, Anne. So a lot of people have heard of what a patent is and know roughly how they function. Not as many people know about design patents, which is a particular kind of patent that protects ornamental design. It functions fairly similarly to a regular patent, but there are definitely key differences. So in sort of legalese, it's for novel ornamental designs of articles of manufacture, and we'll go over what those terms really mean. A fun example to get you thinking about it is Kraft macaroni and cheese. If you've ever seen like this Spider-Man kind or like SpongeBob macaroni and cheese or something like that, Kraft actually gets design patents on those macaroni shapes. So you can see the design patent for that spider web that you see there. And you can tell it's a design patent because the patent number starts with a D. So future reference, you ever see a patent number that starts with a D, you know it's a design patent. All right, next slide. So what is a design patent? Patent is a right to exclude or prevent others for a limited time from making, using, selling, offering to sell, or importing into the US products that have the patented design. It's important to note that having a design patent on something doesn't necessarily give you the right to make that product. You have to make sure that your product is not infringing someone else's IP. Yeah. Next slide. Thank you. So what does a design patent protect? It protects the non-functional ornamental characteristics of an article of manufacture. So some kind of physical product that's an article of manufacture, and protects how that looks. You can get multiple design patents that cover different aspects of the same product. So if 2 different parts of the product, it's important how it looks for selling the product. You can get different design patents for different aspects. To know what's covered in a design patent, you look to the drawings. And it's important to note for those of you who are interested in making software, you can get a design patent on a graphical user interface or GUI, as long as it's displayed on some kind of physical screen, which it generally always is. But the protection only covers the appearance of the GUI, not any functional characteristics, any like how the menus work. If that's really user friendly, it's only about how it looks. All right, next slide. How long does it last? It lasts for 15 years from the date of issue. So unlike a utility, which is kind of a regular patent, or a plant patent, which are very rare but also exist, those last for up to 20 years from the date of filing. So this is from the date of issue. It's kind of a key difference that can mean a matter of years in real terms. And before 2015, it used to be 14 years. So if you're looking at a design patent and you want to know how long it is effective, it's important to know that before 2015, they're only 14 years. Next slide. All right, so how do you get a design patent? So if you design something and key value of that product is how it looks and you want to protect it, first it needs to be for an article of manufacture. So it needs to be for a physical product that you make. It needs to be original, which means you're the one who came up with that design, basically. It needs to be ornamental, meaning it's purely decorative. It's not a functional characteristic. It needs to be novel, which means there's nothing else out there in the world that has exactly the design that you're trying to patent. No single reference has everything that you're trying to claim in your design patent, and that can include your own product. So if you reveal your product publicly or you start selling your product, you have a 1-year grace period in which to file your design patent. If you wait longer than 1 year from when you've revealed it publicly, your design is no longer novel because your own product basically eliminates that novelty. Next is non-obvious, and this is kind of an amorphous concept, but it means there's no simple combination of 2 or more pre-existing designs or references that have everything you're trying to claim. So if you take, part of a design from this product you like, part of a design from that product you like, you just kind of merge them together. That would generally be considered obvious if a product designer could easily do that. It's relative. The term is a person having ordinary skill in the art, which in this case would be a product designer of whatever product you've made. So it needs to be non-obvious, and that can be, there's a lot of gray area for obviousness. And finally, you need to show and describe it in your patent application with enough detail for regular product designers in the future to make that design. You get the monopoly over your design for a temporary period in exchange for showing the world what your design is, so that people can make it in the future. All right, next slide. So about the actual application. Your application has to include, most importantly, drawings. This is generally what you'll prepare for your patent attorney. And it's usually black and white drawings, but you can use color if you need to. Most important about the drawings is that solid lines are outlining the claim subject matter, so the part that you'll actually have protection over. And dotted lines are just for background or context. They don't give you any kind of protection. So in this example with the shoe, the part on the heel, that particular design that's in a solid line, that's what the person is claiming for their patent. The rest of it, the dotted lines, that's just showing you how it goes on a shoe, what the rest of the shoe might look like, but they're getting no legal ownership over that design of shoe. Just the part on the heel that's in solid lines. There is a single claim, which the words are just the ornamental design for X, for example, ornamental design for the heel of a shoe, as shown and described. And it'll have a specification where it has a title and a brief description of what the drawings are showing. An oath where you're swearing that you're the one who came up with the design and you know what the design is. And then, of course, a filing fee, because nothing in this world is free. All right, next slide. So how long does it take? It takes about 2 years from filing, give or take. to get your design patent issued. That's average. And about 3/4 of design patent applications do eventually get granted. So it's not a guarantee that when you file, you'll actually get one, but the majority of them do eventually get issued. Next slide. So important note here, who owns the design patent? Ownership will originally lie with the inventors. So it has to be assigned to your company for a company to own the rights. So for your startup company, it's really important to have an IP assignment agreement for everyone who's a member, an employee, a contractor, anyone who's doing any work where they might create some kind of intellectual property. If you don't have an agreement where they're going to assign that to you, they will get to keep their right, and they can sell that right to a competitor. They could compete with you. So it's important that they're obligated to assign their IP to your company. Otherwise, they'll retain that right for themselves, and you'll have to buy it from them or deal with the competition that brings. All right, next slide. So how much does it cost to get one? An average figure is between $2,000 to $5,000. That's a rough ballpark. And that's for the whole process, applying for, prosecuting, which is where your attorney will kind of go back and forth with the patent office, arguing why it deserves a patent, and to actually receive the design patent, there's fees all the way through. For microentity, which is what most of you probably are, the definition is that none of the individual inventors nor the company individually make more than that number, 202,000, and that number kind of goes up every year. Microentities get 75% off the fees at the patent office that a regular large company gets. In between that is a small company that gets half off. So the PTO fees alone will be $440, and then there will be some attorney's fees if you're paying for an attorney or patent agent to prosecute. So microentities will probably land closer to the 2,000 than the 5,000, but every case is different, and depending on how it goes with the patent office, that could loom towards the higher end there. Important to note that there's no maintenance fees for design patents. Utility patents, you have to pay maintenance fees to keep the protection active. Design patent, once it's issued, it stays there for all 15 years. You don't have to keep paying. All right, next slide. So if you think you have someone who's infringing your design and you have a design patent, or you're worried that you're infringing someone else's design patent, how do you know where the line is? So if you're trying to prove that someone's infringing, you don't need to prove that they intended to infringe your design. You don't have to prove that actual customers have been diverted from your product to their product. You don't need to prove even that they've ever heard of your company, ever seen your product before. If it's covered by the design patent, you can get infringement. So a court will apply what's called the ordinary observer test, where they kind of look at the product, both products, or the design patent and the product in question. They look at it kind of from what an ordinary observer, an average person giving the kind of attention that a regular person buying a product would usually give. And they say, are these close enough that one person might accidentally buy the infringing product when they mean to buy the patented product? So there's a lot of gray area, and closed cases can often go either way depending on how it plays out in court and the jury. So be aware that there can be a lot of wiggle room. It's hard to get a black and white answer on whether or not someone is infringing. And they look at the overall design. So you can't really get away with, oh, but there's a minute difference here. They take a step back and look at the things kind of as a whole to see if someone might be confused. Important to note that defendants can try and prove invalidity of the patent. So even if you catch them and they're infringing your patent, they can try to prove that your patent didn't really deserve to be issued in the first place. So it's important to note that that's a key defense in all patent law. All right, next slide. And so if you've proved that someone is infringing your design patent, what can you get for that? So you might be able to receive reasonable royalties. So the court will say you deserve to get, this percent of money per product that they've sold. You might be able to get lost profits if you can prove exactly how much money you've lost as a result of the infringement. You might be able to get the infringer's total profits. And you might be able to get an injunction where the court says they have to stop selling that product. Those are all options. It'll depend on the facts of the case. And if you can prove that they infringed your design patent on purpose, you can get up to triple damages. So that can add up to a lot of money. Design patents can be very valuable in that aspect. All right, next. All right, looks like moving on to trade dress. So I'll hand this back to Anne. And you are still muted.
Apologies for that. I was waiting for the thumbnail to show up and it took a hot second to do so. All right, so I'm going to talk to you about trade dress for distinctive designs that indicate the source of a product. And so trade dress is actually a really fun thing to talk about because it covers a lot of things that we see around in our everyday life, like the shape and packaging of Hershey's Kisses, the shape of these lovely goldfish, and some restaurant design. So what is trade dress? Trade dress is a kind of trademark that covers the look and feel of a product. So take a step back, what's a trademark? Trademarks are a kind of IP protection that cover symbols that indicate the source of a product. So for example, a logo or a slogan, or even just the name of a company, a brand, those can all be trademarked. And what that's doing is showing a consumer, for example, that the shoes I bought with the swoosh on them come from Nike, and that's the concept that a trademark is meant to protect. So trade dress protection, unlike a design patent, belongs to the company, so the source of those goods, right, instead of the person who came up with the design. So trade dress protection is great in many senses because it can last indefinitely. So there are a lot of big famous brands that have had trade dress protection on their products for a very long time. However, only distinctive designs are eligible for trade dress protection. It's not enough that you've come up with a new design. That design has to be distinctive. And some fun examples here, we have Converse shoes. Apparently I love shoe examples. And a Jack Daniel's bottle. So there's a wide variety here. So what is distinctiveness? Distinctiveness is the concept that a design is associated with a company that's making the product. So for example, you can see this bottle and see the lines and the shape and think that's a Coca-Cola bottle. That beverage came from Coca-Cola. You can see a red sole on a shoe and think to yourself, that's a Louboutin shoe that came from that company. And having that association between a product and the source of that product can take time to develop, as you might well imagine. Consumers have to identify the product and then associate that back with the company that makes that product. But you can use marketing to help establish distinctiveness. And that's one of the things you can really use to show distinctiveness is that you've done marketing. You can also use surveys showing that customers see the red shoes, the red soles on your shoes and say, that's a Louboutin shoe. But again, you want to be careful when you're thinking about getting trade dress protection that you're really limiting it to what it looks like and feels like, not what it does. Because again, the function of these things is not what trade dress is meant to be protecting. It's just the symbol of where these products come from. How do I get trade dress protection? All right, so trade dress can be registered at the USPTO like other trademarks. Trade dress registration requires that the design is distinctive. We just talked about it's associated with the company. It identifies the source of the product, and it's being used in commerce. If you want to register at the USPTO, you need to show interstate commerce for that federal registration. And like I was just talking about, you need to show that the design is primarily non-functional. So if you look over at this corner, you see this box, this Tiffany box, and it's that Tiffany blue. And the blue is part of the trade dress of the Tiffany company. It's been associated with that company. If you're a certain kind of person, you see that color, you think that's Tiffany blue. And of course, they can't cover the concept of having a box or the concept of putting jewelry in a box, but you can get protection over the color of the box. Or if they'd made it a fun shape or something, perhaps that. All right. Even though trade dress can be registered at the PTO, it doesn't necessarily have to be. Trade dress that is not registered can still be protected if you can show, when you're trying to demonstrate infringement, that the trade dress is distinctive, that it's not functional, and that there's a likelihood of confusion with a competitor. So here I have a picture of a restaurant, because restaurants and the decorations in a restaurant, if they are distinctive to that particular restaurant, could be covered by trade dress protection. And the restaurant isn't necessarily going to go out of its way to protect it unless it's McDonald's, for example. But here it's a Mexican restaurant. And so you have the colors of the awnings, the shape of the entrance. And so you might be able to get trade dress protection. There's actually a very famous case about a Mexican restaurant that had this trade dress protection. They hadn't registered, but they were able to prove these elements. It's an interesting case. So how do you prove trade dress infringement? All these things are only important as much as you can, use them to protect your product and your brand. So to sue for trade dress infringement, you need to show that, again, the design is distinctive, the design is non-functional, you were using the design and it became associated with your brand, became distinctive before the competitor who's using it. And you need to show that the infringing product design is likely to confuse consumers. So likelihood of confusion is a legal standard. And basically what courts will do is go through several factors looking at, how different the trade dress of the two companies is, the two products is, how sophisticated a consumer is. So unlike with patents, design patents, if, for example, you're using trade dress to protect something that you market mostly to large corporations, those are very sophisticated consumers. And so you're going to have to show, the bar to show that they would be confused is higher than a normal person who's just buying things because they like them. And there are a few other factors, but it's that sort of inquiry. Again, alleged infringers have defenses. They may defend themselves by claiming that your trade dress is invalid, that it doesn't have those options that I said above, distinctive, non-functional, that they were using it before you, that their product is not going to cause confusion. And sort of in that line, they can also show that they took steps to avoid confusion. So one of these examples of doing this that happens a lot is that if you have trade dress that's similar, but a competing brand prominently displays their brand name or logo. So if you have two shoes that look pretty similar, one of them has the swoosh and the other one has, a huge Keds logo on it, then Nike would have a harder time showing that Keds was trying to confuse consumers. So what remedies can I get for trade dress infringement? So you might be able to receive lost profits. If you can prove that, you might be able to get your competitors' profits, whatever they made on these companies that are infringing your trade dress. You could get an injunction. And sometimes you can get attorney's fees, but that's rare. You kind of have to show that what they were doing, they knew better than to be doing that, and that it was kind of egregious. And that's sort of a similar thing, cross attorney's fees in many cases, if you can get that. So here I have a picture of a John Deere tractor at the top, and underneath that is an infringing piece of farm equipment. The colors were what John Deere asserted trade dress protection over, and they actually won an injunction. So this company who makes this farm equipment had to stop making it in the iconic yellow and green. All right. And now we're moving on to copyright protection. And copyright protection is not just for books anymore. It never was, but you cover a belt and a cheerleading uniform. So what is a copyright? So a copyright is a kind of IP protection that covers creative works. So books, music, paintings, statues, for example. The design of a useful article can be eligible for copyright protection. This is sort of like a design patent where you're talking about a useful article, meaning something that is functional in some aspect of it. Like, for example, what you're looking at here is a lamp, right? But to see if a lamp is eligible for copyright protection, you need to look at it and see if you could imagine it not being a lamp, if that would be, graphic art, a sculptural work. Here, this lovely moose lamp could be a sculpture if it didn't actually turn on as a lamp. So it's likely eligible for copyright protection. Copyrights belong to the author, so the person who generates the work, unless the work is a work for hire. And so sort of like a design patent, if you're going to hire someone to make a product for your company, you will probably want to make sure that their contract is clear about what they're doing being a work for hire, so it belongs to the company. How do you get a copyright? Copyright protection requires that the work is original, meaning that you made it, or it was a work for hire for your company. It requires a modicum of creativity, which basically means that there's something expressive about it. If you have a pattern of just a bunch of different triangles together, you have a t-shirt that has a triangle on it, that's probably not going to pass the modicum of creativity hurdle because triangles are everywhere. If you look for them. No, but basically this is a pretty low bar, but it's a bar that exists to make sure that copyrights aren't used to exclude people from using common symbols. We want people to be able to be creative and only protect things that really required some sort of innovation. And they also have to be fixed in a tangible medium. If you are making a product design, you don't have to worry about that. Fixed in a tangible medium means that it exists as something that you could pick up and touch. And if your product design isn't able to be picked up, touched, handled, you probably have bigger problems than what we're talking about here. So how do you get one? You don't have to apply to the US Copyright Office for a copyright. Once you make the work, there is a copyright that you own in that work. But even though you don't have to register to have that copyright, registration has its benefits, as you might expect. One, you can't sue for copyright infringement unless the copyright is registered. So that's a huge benefit to registration, because if you're going to go through the trouble of designing, marketing, and having this thing that's your product, you want to be able to sue people if they try and take it. And then if you win a lawsuit, you can get more money with having to prove slightly different things. So statutory damages. I'm going to explain that right now. Nope, in one slide. So how do I prove copyright infringement? So copyright protects against copying expression, not ideas. So what you need to do is show access and similarity, because you can't copy something that you have zero access to, and it's not copying if it's completely different, right? But those are a sliding scale. So if something is all over the place, like boxes of Arm & Hammer baking soda, and you have a huge amount of access, then you are not required to show as much similarity. So even if these two were slightly less similar, Arm and Hatchet would probably still be in trouble. And the same thing goes for similarity. If they're very similar, then the requirement that you are required to show that they are not required to show as much access because they're so similar. If you can show a lot of both, that's great. So it's not like either one of those is going to stop you as long as you can show a lot of it. Okay. You can show infringement by demonstrating that you have a valid copyright and the work that is at issue was illegally copied, so without your permission. And alleged infringers can defend themselves by claiming that your copyright isn't valid, that their use was fair use, or that they didn't copy. So fair use here is basically if they use that logo or if they use your product design to talk about your product, to critique your product, or to, in some cases, like resell the product. So they're not using it for commerce, they're using it for speech, for communication, because we want people to be able to communicate about products. And so normally if they're not doing this for a commercial purpose, it is more likely to be fair use. And showing that they didn't copy is actually quite hard because you don't have to show that they copied on purpose. If Arm & Hammer baking soda, as it is just generally around everywhere, there's such a thing as subconscious copying with copyright. So you don't have to prove that they actually thought, haha, I'm going to copy this. You just show access and similarity, and it's hard to get out of that. So what remedies can I get if I prove someone infringed my copyright? So you can get lost profits and infringers' profits, so what you would have made and what they did make, or you can choose statutory damages, which is what I started to talk about a little too early a couple of slides ago. So statutory damages are damages that are set by law. And so basically you can get a certain amount per article that was infringed. And so this amount is actually a range, and it's higher for willful infringement for profit. So if you can show that they copied on purpose and they meant to sort of take your IP and make money from it, you will get higher statutory damages. And statutory damages are nice because you don't have to prove that you lost money. You don't have to prove that they made money. You prove that they committed a copyright infringement and you can get statutory damages. However, statutory damages are only available if you've registered the copyright before the infringement or within 3 months of publication of the work. You could also, in some cases, get attorney's fees, but attorney's fees are available at the same in the same circumstances as statutory damages. You have to have registered the copyright at the Copyright Office before infringement or within 3 months of publication of the work. So if you're interested in suing people at all, you want to register that copyright. It has a lot of benefits. All right, now Ian's going to talk to you about how to think through which of these is good for your product.
All right. So we'll talk about what's best for your product, kind of the differences and similarities, and when you might want to pursue each of the options. Next slide. All right. So comparing the options, they all have slightly different aspects to each of these. So copyright, the standard for copyright is very low. It's very easy to get a copyright. It just needs to be basically a little bit creative. Design patent has a pretty high bar. It needs to be novel, so no one's ever designed something quite like this before, and non-obvious. No one could easily design something like this, taking 2 or more things that already exist. And then trade dress, it needs to be distinctive. So you need to have people who recognize that a certain company is selling a product that looks like this. They associate the product with a particular company. The length, copyright lasts a really long time. It's your entire life if you're the author, plus 70 years on top of that. If it's a work for hire, it's less, it's like 95 years standard, but still a very long time. Design patent is just 15 years, and then it's in the public domain, unless there's other protection afterwards. And trade dress lasts indefinitely as long as it continues to identify the source of the product. For infringement, copyright, you have to prove that somebody copied you, which can, in some cases, not be too hard to do. But a design patent, you don't have to prove that anybody ever heard of you, saw your product, had anything to do with you. You could be on completely different sides of the country. If you can prove that their product to an ordinary observer could be confused with the product that you patented, you can get them for infringement. And then trade dress, you have to prove that, it's likely to confuse customers about who's making this particular product. And they all have different costs. So copyright is pretty cheap, just a $45 or so filing fee, plus some attorney's costs, which is not very much. It doesn't take long to register a copyright. Design patents take a bit longer and cost a lot more. So you're spending probably $2,000 to up to $5,000 total. to go from idea to design patent in your hand. That'll take roughly 2 years or so. Filing fee, just the initial filing fee for micro entity is 55, regular entity is 220. And then trade dress, there's a filing fee of a couple $100, some attorney's costs, which will be not too much, maybe a little bit more than copyright, and you will have to renew the trade dress, so pay some regular fees. All right, next slide. So here's how you could use all three. If you have a design, it's the key selling point is how your product looks. Its aesthetic value is very important to your company, and you want to get as much protection as possible. Here's the order you want to do things. First, you want to file your design patent application. Ideally, before you've ever shown the product in public, but if you've already started selling or you've already announced and shown the product, if you're still within 1 year, then you're okay, in the US at least. It's different in other countries, and patents are specific to a particular country. So once you've done that, second, you want to register the copyright. Basically right after you've done that, or within 3 months, so you can get statutory damages when you sue. Third, if you want to start selling and marketing your product, you want to start building that brand recognition. People associate that product with your company. And if you already have your patent protection, then no one else can start making a similar product. So it's important to do those first. And then fourth, once you have distinctiveness, you want to file for trade dress protection. And then once you have that, you keep selling, enjoy your company, and keep an eye out for possible infringers. Because if you let people sell products that are identical to yours for a long time, that can really undermine your ability to get any damages if you're not trying to police your mark and make sure that you're the only one selling the product that looks that certain way. All right, so next slide. And wrapping it all up. So product designs can be very valuable. Aesthetic value, especially for particular products like shoes, apparel, accessories, cars, decorations. Sometimes aesthetic value is the value of a product, and you definitely want to protect it if that's the case. There's three main forms of IP that you can use to protect those designs. Get a design patent, you can get trade dress, and you can get copyright over that. Any combination of the two or all three. And very important to remember, this only protects how a product looks. If your product looks a certain way because it has to in order to function a certain way, then you can't get protection over it because it's for the function. So it has to be purely aesthetic value that you're protecting with these forms of IP. If you are trying to protect the functionality, you can get a utility patent on it. Or if it's not public and you want to keep it under wraps, there's trade secret protection, which is also an option, and that's also indefinite as long as you can keep it secret. So that's everything. Please let us know if you have any questions at all. We'd be happy to help.
Feel free to check out the Startup Law website and our sister clinic, the Tech Law Clinic.
Yes, there are a lot of resources about IP, about everything relating to startup, a lot of good resources if you don't know a lot about the legal regime around this. It's a great free resource that you can access.
Yeah, Leslie and Austin, if you have any questions, you've got these guys here for a few more minutes, and and they're happy and prepared to answer them. So, but thank you guys for being here.
Thank
I
you.
appreciate that. Thanks, guys.
Thank you, Leslie.
Yeah, you bet.
Austin, yes. Jim, do we have a clinic email that we can share?
Yeah, if you, it's startup at startup law, right, Sam? Startup law at bu.edu.
It's It is, actually I haven't had to, that's the general email is, let's see.
Put that in chat, I think.
And Austin, while he's checking that, we also do, we also meet with people on a consultation basis, even if they are not ready to pursue legal work. If they've got questions about how something's going to work and they need to understand it better, we set up appointments on a consultation basis. So tomorrow we're done with that basically for the semester, but we'll be back in January to doing those appointments every Thursday and Friday. And the way to access that is to fill out the form on the website that you see on the last slide up here. And Sam has just put the email address, which is just startup, not startuplaw @bu.edu.
Yeah, thank you. So I have a quick follow-up question because I'm not a BU student. So I'm just kind of curious if our team, because we have one MIT student in our team, so we're just kind of curious if are we able to use the consultation for the clinic, or yeah, just kind of curious about that.
Yes, if you have a current MIT student in your group, then yes, you can access our clinic services.
The one caveat is the person needs to be a leader on the team. It can't be like someone who's like an employee or just essentially someone that you boss around. They have to be a clear, part of management who, helps run things.
Great, thank you. Yeah, also I have another follow-up question, if that's okay. I'm not sure if it's a good question to ask, but I'm currently a student at Harvard, but I'm just kind of curious, are there any similar services at Harvard that you might be aware of? Because I'm not sure if I know any of that.
I can answer that. Yeah, Harvard, the law school, just like us at here at BU, they also have a series of clinics, and they do have a transactional clinic. So if you just kind of Google Harvard Law School transactional clinic, you'll find their website, and they should have instructions on their website for how to apply for their services. And they may also have some resources on their website for you to look at.
Okay, thanks so much.